In a medical malpractice trial, do I have to reveal to my opponent exactly what witnesses I am calling to the witness stand on each and every day of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, no, I do not have to reveal to my opponent exactly which witnesses I am calling each and every day. But I'm going to share something with you that a lot of people don't talk about. Before your trial actually starts, the judge meets with the attorneys in his private chambers. And he wants to do that because he wants to know what this case is about. He's just been assigned our case randomly by the trial assignment judge. And now the judge knows nothing about your case. So he asks the attorneys to come in and speak to him in his private chambers. And he basically says, "Counselors, what's this case about?" And now in the span of 1 or 2 minutes, we give him a summary of what the case is about. The defense tells him what his position is as far as negotiation, as to whether or not they're interested in trying to negotiate. And then the judge gets into the logistics and scheduling of the trial. Counselors, are there any issues with witnesses and scheduling? How many witnesses do you plan on calling, Mr. Oginski? Defense counsel, how many witnesses do you plan on calling? All right, now he knows how many. He may even say, okay, who are your witnesses? All right, Judge, I have the injured patient, I have my medical expert, I have the injured patient's husband, I have the following other witnesses. And now he turns to the defense lawyer and says, who are your witnesses? Oh, we have the doctor, we have various experts coming in. And then, in some instances, the judge may turn around and say, who are your experts? Now, that's a little bit of a dicey question. And why is that? Because there is no requirement, and in fact, we do not notify our adversary about the exact name of each of our experts. Instead, we have to track them down based upon their credentials. And then we have to get some dirt on them or try and find some dirt on them once we identify who they are. But sometimes the judge will turn around and want to know exactly who it is. He may have a problem with that particular witness. Or my opponent may have a problem with this particular witness, and now the judge will have to make a legal ruling before the witness ever takes the witness stand. So let's go back to the title that I raised in this video. Do I have to notify my opponent of which witnesses I am calling to the stand? The answer is no, I don't. I don't have to tell him I'm calling the injured patient today, then I'm putting on my expert later in the afternoon, and then I'm calling the next witness right afterwards. I don't have to do that. But as a courtesy, you will find that some of the best trial attorneys go ahead and ask each other, hey, by the way, who are you bringing in today? Hey, do you have your expert coming in? Because my expert is only available tomorrow, and now they try and work out scheduling. So in many instances, it is advisable to talk to your opponent to find out whether or not he's got an expert lined up for the next afternoon or the next morning, or whether there's a gap, because there may be instances where there's no witness available for a particular morning or a particular afternoon. In that instance, the judge wants to fill up that space. And sometimes he will take a witness out of order. Now, what does that mean? It means that we have an obligation, since we are the ones bringing the lawsuit, we have an obligation to show that we are slightly more likely right than wrong, that what we are claiming is true. And we do that with various testimony, with various witnesses, with the evidence that we put on. And it is our obligation to continue day to day with putting on our proof in order to show that we're entitled to a verdict in our favor. Then, when we are done with whatever proof is necessary, that we believe is necessary to get a verdict in your favor, then we say the plaintiff rests, which means we're done putting on all our proof. Then it becomes the defense's opportunity to put on whatever testimony and evidence they feel is necessary to defend the case. If a judge is willing to take a witness out of order, it likely means that I don't have a next witness for the next afternoon or for the next morning. In that instance, the defense lawyer may have a witness available to put in his place, to say, okay, Judge, I can get my expert to come in this afternoon. I know Mr. Oginski doesn't have anybody. Can we take him out of order? And most of the time, the judge will say, fine, we are going to take that witness out of order as an accommodation. It doesn't mean that we're done putting on our proof, because that would be a problem. Because now if I turn around and said, Judge, my witness is coming in the day after, and he says, no, no, no. You gave up that right once you said you were done. Judge, I didn't say I was done. So all that means when you take a witness out of order is we're going ahead and stopping putting on our proof. Why? Because of a scheduling problem. And now we're taking one of the defense witnesses to go in its place. And then after he's done, the next day, I can go back and continue on with my witnesses. So why do I share this great information? I share it with you just to give you an insight and an understanding into what goes on at a trial involving medical malpractice matters here in New York. You know, I do understand that you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, but you're thinking about bringing a case, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.